At the outset, for information purposes, pursuant to the Standing Orders 111 of the Standing Orders of Parliament, all committee meetings are to be open to the public. Therefore, this submission meeting is open to the public and the media and will be aired live on the Parliament's channel through the Wallis platform and live streamed through the Parliament's Facebook page. For any sensitive information concerning the submission that cannot be disclosed in public, this can be provided to the committee either in private or in writing, but do note that this will only be allowed in a few specific circumstances, which include national security matters, third-party confidential information, personal or human resource matters, and meetings whereby the committee deliberates on all issues before it and develops its recommendations and reports. I wish to remind honourable members and our invited subcommittees that all comments and questions are to be addressed through the chairperson. Also be mindful that only the invited subcommittees will be allowed to ask any questions or give comments to the committee. This is a parliamentary meeting, and all information gathered here is covered for under the Parliamentary Powers and Privileges Act and the Standing Orders of Parliament. But please note that the committee does not condone libel or slander or any allegations against any individual that is not present here today to defend themselves. In terms of other protocols of this committee, please be advised that whilst the meeting is in progress, movements within the meeting room will be restricted. There should be minimal usage of mobile phones, whereby answering the phones should be done outside this room, and all mobile phones are to be on silent mode. Now I would like to introduce myself, and following this, I'll ask the honourable members to introduce themselves. My name is Sekiusa Tumbuna, and I am the chairperson of the Economic Affairs Committee. Thank you.
Semi Coreleusa, member of the committee.
Jesus Okuru, member of the Economic Affairs Committee.
Vinona Dolo Alpati Dolo, member of the committee.
Honourable Kumar.
Premila Kumar, Deputy Chair of the committee.
Thank you. With us this afternoon is the representatives from Munro, Leys, Mr. John Apted, which the committee has invited to provide us a submission on the Employment Relations Amendment Bill, Bill number 27 of 2025. The Employment Relations Bill introduces substantial reform to the Employment Relations Act with 142 proposed amendments aimed at strengthening compliance and enhancing worker protections. Key provisions include the introduction of fixed penalty notices, allowing labour inspectors to issue instant fines of up to 1,000 and a broader civil penalty regime with fines reaching up to 100,000. Employers also face stricter liability for wage underpayment, with penalties for companies potentially reaching 1 million. Additionally, the bill expands the powers of the labour officers and inspectors, enabling them to enter and inspect business premises without consent when reasonable grounds exist, seize documents, take samples, and issue penalty notices, reflecting a significant increase in regulatory oversight. Alongside compliance measures, the bill seeks to reinforce worker protections by strengthening unfair dismissal provisions, increasing redundancy, compensation, and expanding leave entitlements. It also introduces criminal liability for employers in cases involving unjustified dismissals, unfair redundancies, or workplace sexual harassment, and proposes bargaining fees for non-union employees benefiting from union negotiations. The bill proposes new protections for women, including specific leave entitlements that address menstruation-related health needs, and also introduces miscarriage leave offering structured support depending on the stage of pregnancy. Women who suffer a miscarriage between 0 and 12 weeks may receive 3 working days of leave, while miscarriages occurring between 13 to 23 weeks may entitle them to 7 working days. Miscarriages occurring from 20 weeks onward would fall under maternity leave provisions. These reforms aim to provide compassionate, equitable support for women experiencing pregnancy loss and ensure that employees uphold minimum standards of care and dignity in such circumstances. With this, the brief introduction, I now take the time to invite our guest. Perhaps maybe after this we'll ask him a few questions, and we'll ask him to answer some of the questions that we have that we will be asking him. But Mr. Apted, welcome again to this session. We have noted that in the media that you have outlined some of your comments and not maybe no criticizing the bill, but you airing out your comments with relating to the bill. And one of the comments that you made with regards to the bill is that the types of legal action, for the same type of legal action, the employer can face up to perhaps maybe 3 types of the legal action not to be taken in case of civil proceedings, and then after that it's being upgraded to a criminal, and also there are some charges straight that the employers will be charged if they if there's some part of the bill that they would breach. So I think that's to start off that our the conversation this afternoon. Perhaps maybe if you can just expand on that. When for a single offense, a person is charged perhaps maybe 3 times under the proposed bill. Perhaps maybe if you can explain to us what are those specific elements of the bill, and if you can mention to us what section of the bill are you referring to, and how the employer can be charged 3 times if he in terms of if he breaches this new bill that we are proposing to Parliament. Binaka, thank you. Maybe I will give another time to you now, Mr. Apted. Binaka.
Thank you, Mr. Chair, and committee members. Thank you for the invitation to appear this afternoon. I apologize first. I have been really busy, so I have not prepared a written presentation. I'll be speaking off the cuff, and I think a person from your secretariat who contacted me said I would just answer your questions. Before I go to the questions, before I address your first question, housekeeping first, how long do I have?
You exactly have 1 hour, or
Okay.
it can be more.
Okay. Before I answer your question, though, I just need to give some context, right? I'm aware that this bill has come about through consultations between the ministry within the Employment Relations Board, from representatives of employers, unions, and the ministry. They were not allowed during that 2-year process to consult anybody outside. They were required to sign non-disclosure agreements and to speak within. So what that meant was that the views and the ideas that eventuated in the first draft bill did not reflect the interests of the people who they were supposed to be representing. So the bill has since gone to Cabinet and AG's office, but a lot of what is in the version that is in the House doesn't reflect what employers necessarily want or workers necessarily want. So that's point number 1. Point number 2 is, in this process, the employee reps, the worker reps within ERAB are union members. So they come from the large unions and the large employers, large workforces. They don't represent the views of the smaller workers and people from smaller businesses. The third point needs to be understood is that when it was in this context, although there were members of ERAB from other government departments, broader national objectives don't seem to have been taken into account. The need to promote investment, the need to promote employment, the cost, how the court system works, they were not taken into account. What seems to have happened is that the ministry came up with its own ideas of reform to the existing ERA based on problems they felt they had in enforcement, right? The mistake a lot of people make is that where you have an administrative enforcement problem, it's not necessarily a question of reforming the law. The cause of your problem may be skills, may be resources, may be misunderstanding. So this permeates, and I will come to it, the proposals in the bill. They are a sledgehammer solution, to, in my respectful view, to problems that are about skills. Okay? So that's number two. Number three, the unions have sought advances in workers' rights because that's their job, but there was no pushback within the committee, or there was pushback by the employers, but they were a minority. So proposals are in the bill, as I said, that don't reflect necessarily the interests, they don't try to balance the interests of the country. They reflect the views of workers, or as represented by unions. So I'll come to your question now. What has happened? Okay. Let's start with the existing Employment Relations Act. Okay? Under the Employment Relations Act, as it exists, there are various requirements and existing offenses. The offenses that currently exist are for black and white matters of breach. For example, if you don't pay the amount required by the wages regulation order, you commit an offense. If you don't keep records, you commit an offense. All of those things are objective. You know, you can prove it by looking at it. So there's a whole lot of offenses there already. What seems to have happened is that the Ministry of Labor had difficulty enforcing those offenses against certain problem employers. Not every employer, certain problem employers in, and I understand, in a particular industry. Right? So they've come in and they have suggested these huge fines and all of these additional things as if that's going to stop breaches. But if the existing offenses didn't stop the breaches, increasing the penalties, or increasing the number of offenses is not going to do this, it's not going to stop them either if you don't have the enforcement skills and you don't have the enforcement mechanisms. You know, so if I could use a very current example, we have a drug problem, right? If it's a problem with police resources and prosecution resources, you're not going to solve the problem by increasing the penalties. You've got to deal with the resources. And so this is the problem with the approach. The second problem with the approach is that they overlook the fact that almost every person is an employer. I am an employer in my house. I have a housemaid, I have gardener. These penalties will apply to me. I'm sure many people in this room also employ staff. These will apply to them. The little market vendor may hire somebody to work for him, or a farmer to work in the garden. These penalties and these new offenses will apply to those people. Okay, so this is not just going to hit the big bad employers, it's going to hit anybody who employs. What they have done is not only create new offenses, some of the offenses actually overlap with things that were already offenses. So they doubled up the offenses. For example, the new wage theft offense overlaps with an existing offense. In section 247 of the ERA. And 247 of the ERA already makes it an offense not to pay wages without reasonable excuse. It's an offense punishable by up to 100,000 in fine if you're a corporation, or 20,000 if you're a business, if you're an individual. So there's already, the offenses are already there. The offenses already have significant penalties. And by adding new offenses with stricter guidelines that overlap and duplicate with even higher penalties, you're not achieving compliance. All you will be doing is discouraging foreign investors from coming in. Because foreign investors look at potential liability. You know, so why would you invest, for example, in a call center where if you make a mistake in wages, you could face $1 million fine? Why would you come to Fiji? You'll go to somewhere else that has easier access. So that's for the wage thing. A number of the other offenses, and this is the thing, a number of the other new offenses are matters that are not objective. Okay? So if I can give you an example. For example, when you dismiss somebody, whether the dismissal is justified or unjustified is not a black and white issue. It's not like speeding. It depends on judgment. So I might think it's justified, the tribunal might think it's unjustified, the High Court might think it's justified, the Court of Appeal might think it's unjustified. People's view of whether a dismissal is justified or not will differ, because it's not black and white. At the moment, the Act allows the affected worker to seek compensation. So there's already a remedy. Now, on top of that compensation, they're making it an offense. Right? Why is not, they've never made clear why they need to make dismissal, unjustified dismissal, an offense on top of compensation. Then they've also provided that it can also be the subject of a civil penalty. Okay? What we need to understand about criminal offenses is that when you commit a criminal offense, it goes on your record. You have a criminal record. So if you unjustifiably dismiss your house girl and she takes you to the Ministry of Labor and they decide to prosecute you, you now have, and you're convicted, you now have a criminal record that will prevent you from getting a visa. Even corporations, major corporations, don't like to have criminal records because it affects their standing in the community. So why it is necessary to expose people to criminal sanctions when there's already a compensation regime and when the conduct is not, the rules are not black and white, it's about subjective judgment, is not clear to me. Then, like I said, so that's the criminal side. But they also created what's called civil penalty liability for certain of them. And a civil penalty is used in legislation instead of criminal. Right? So where there's a breach, the law, the parliament can decide that that's a civil penalty situation where the court can order you to pay a penalty, but you don't get a criminal record. So here, a certain range of new offenses, which shouldn't be offenses and are not offenses anywhere else in the world, still have compensation if the worker takes it on a grievance. Now the potential for criminal liability and prosecution, and also potential for civil penalty, the same conduct. Okay? There's three things wrong with this. First, it means every time you want to dismiss somebody, and your company or your house or your business might need that person to be dismissed, you'll be frightened to dismiss them because not only might you have to pay compensation, but they're going to go running to the police station or to the Ministry of Labor for you to be charged with an offense. You know, so every time you dismiss somebody, they've got a stick to hit you back and drag you there over something like a sacking. They also, the other problem is that it means that business, you'll be frightened to even employ anybody. Because by employing people, you open yourself up to this kind of massive liability. It also, the problem with it also is that it gives both the bad people who breach and labor officers an incentive for corruption. Because civil penalties and criminal charges are controlled by the ministry. So if you are an unscrupulous inspector, as soon as your former house girl comes and complains against you, they will come to you and say, we have a complaint. They could come to you and say, we have a complaint. We can charge you. The fine is $100,000 and you can go to jail. Or we can do civil penalty. Vavava. You know, so it's just ripe for this kind of corruption. And the opposite is true. Even an innocent labor officer, if I was a bad employer, I could say to the officer when I'm faced with this, how about I just give you this amount of money and it'll be tempting. So we are creating huge opportunities for corruption. The other thing that's a worry about the offenses in this bill is they've taken out the oversight of the DPP. You see, normally, at least with police prosecutions, the police investigate, the police can prosecute some, but the DPP has the final say. So you can go to the DPP can review the file and say, not enough evidence, close it. The Ministry of Labor employment system has everything within the Ministry of Employment. They've taken out the oversight of the DPP. So that's an even greater incentive for corruption, because they're not accountable to anyone. So those are my objections in principle. And I'll just take you through, I mean, I know it's a bit boring, but I'll take you through some of the examples, right? New offense is if you recklessly enter into a contract that contravenes the ERA. I do a lot of employment work, right? And I deal with major employers. The number of cases I find where employers have contracts that breach the ERA. And that's innocent because they copied a contract that was on the file from 10 years ago. They copied a contract from Australia. They don't mean to breach the ERA, but it does, right? You yourself, is all your contracts with your housemaids and gardeners compliant with the ERA? If they're not, under the bill, you'll be liable for criminal offense and a criminal record if convicted, civil penalty, etc. So these are things, At the moment, if they're not compliant, you are required to pay the right thing. This is going to make you pay, plus give you civil liability and criminal liability. Duty to provide work. There's an existing duty in Section 24 to provide work in accordance with the contract. As we all know, a few years ago, COVID came along. We were not able to provide work. Whether that was justified or not, the unions were arguing. Government was forced to amend the act to allow employers not to provide work. But that just goes to show how arguable this kind of thing is. At the moment, if you don't provide work, you still have to pay. This will add criminal liability. And situations are unpredictable. I'll use the current situation we're in. We have the fuel crisis starting. As a result of that fuel crisis, businesses may not be able to provide work to everybody. If there's not enough fuel to bring you to deliver goods, you won't be able to keep your staff. Currently, the law allows the staff to claim the money. That's fine. Why do you need to make the employer criminally liable and subject to a civil penalty on top of it? No justification has been given. There's others like termination on notice, foreign contracts, wages. There's a new offense that if you don't pay wages or other entitlements on time, you commit a criminal offense and you face a fine if you're an individual of 20,000 first offense, 200,000 if you are a corporation. People are late with payments, sometimes because they can't help it. And with all due respect, as I've said at public forums before, and this is not a criticism, but the most well-known offender of this is the government of Fiji itself. The Ministry of Health is constantly behind on overtime payments. The Ministry of Education is behind on allowances because of the system. So how can the government make it a criminal offense for
We have
private
no comments on that.
private? But that's for the committee to, to make it an offense for other employers who face difficulties, and yet, on a huge scale, and I'm not talking about one or two people, all nurses, all orderlies, waiting for months. So, should it be a criminal offense? Because if this goes through, will the Permanent Secretary for Health be charged? Because he's the employer. Under this constitution, he signs the contracts with all those people. So is he going to be criminally liable? And the thing about the offenses to remember is each worker, each occasion is an offense. So if you have 100 workers and you're late 4 pays, that's 400 offenses. At the moment, there's a remedy, you get ordered to pay. Right? So if you're made criminally liable, the question is, why do it? Because it's not like it's going to deter you and make you pay if you don't have the funds. This is not a situation where everybody's doing it deliberately. Sometimes you just can't. So there's that. It just hasn't been thought out. So those are the issues relating to things. So to sum up, there's a whole lot of new offenses that either are already covered or are not black and white issues. There are already remedies for it. There's no reason why it should also be a criminal offense. And there's certainly no reason why it should be a criminal offense and a civil penalty. If you must, do something for any of them, it should be just a civil penalty. But only where it's a clear-cut matter and there's no intention. So that's the first lot. That's the answer to your first question. Thank you for your patience.
Thank you very much, Mr. Apted. Now I'll give the time now, perhaps maybe to the honourable members, if they have any issues that they would like to raise with you while you are here. Perhaps maybe this is the time to give to the honourable members. I just have one question with regards to, you raised about that this law could make could see the Ministry of Employment turning into a money-making business.
Yes.
I think you had raised that in one of another forum. And we saw that some of the charges being made are quite exorbitant, and the committee is looking at into that. How can we ensure that the breaches it has to be adequately also be in line with what the charges that is being prescribed under the bill. So on the money making, we saw your perspective, but I think there are some improvements that the committee has thought about that in terms of trying to improve on that.
If I could just respond
Yes,
to that,
please.
Mr. Chair.
Yeah.
The problem here, and that's a very good point you raised, the problem here is that the legislation creates this fund called the Employment Relations Fund. Okay? The ministry, and then there are existing regulations which say that the minister can authorize payments out of the fund. Okay? So the ministry, when fining, it will go into this fund, and I suspect they think that the money in the fund is theirs to use as they see fit. So it becomes like a slush fund that the ministry can use for a trip to Rome, for song or farewell party for the minister, welcome the permanent secretary, new uniforms, lovely computers, nice air conditioning, all of this. But with all due respect to them, I think that they are mistaken that when they think that the regulation is valid, because the Constitution says that all funds for the use of government must be appropriated by Parliament.
Correct.
So, yes, they can have their own fund within the ministry, but they cannot spend unless the budget approves the expenditure. So that's a separate point. But I have always suspected that all of these fines and fixed penalty notices are partly motivated by this idea that they're going to collect a lot of money that they can use for enforcement and making their terms and conditions better and all of that. But that's not the purpose of criminal offenses. Criminal offenses are not taxes. And individual employers who breach shouldn't be funding a ministry. That's not the purpose of criminal law. Criminal law is supposed to punish and deter. It's not to raise revenue. The proper way to raise revenue is taxes.
Thank you, Mr. Apted. Honourable members, now I'll give the time now perhaps for honourable members that are here to ask any questions to Mr. Apted. Maybe Honourable Kumar, who is joining us on Zoom from Sydney.
Befitting response to the question you asked. This is something that we have been talking about in our committee, and during our consultation, concerns were raised. Even the written submissions that we have received also talks about it. But my question to Mr. John Apted is more on MSME. When we talk about offense, if it's clear-cut, offense is an offense, we understand that. But when it comes to the payment of fine, MSME against big corporations, and currently, when you look at the fines like 100,000, 20,000, 50,000, even 1 million, how can we protect MSME from such fines and yet do not create a sort of two system where we say offense for MSME is treated differently, whereas the same offense is treated differently for bigger corporation. How can we find a balance in that? Thank you, Chair.
Thank you. Mr. Apted, do you have
Yes.
an answer to that?
Yes, thank you for the question, Primla. Overseas, I can use the example of Australia. In the Australian legislation, their equivalent of this, they distinguish between small businesses and big businesses. Because at the moment, even in the ERA, there are different fines for individuals and corporations. So there's already a distinction. In the Australian legislation, the penalties distinguish between small businesses, which are defined as businesses that employ this many people or less, and big businesses, which are that way. So it is possible, and it is internationally accepted, to distinguish in fines. You can't say it's an offense for a big business but not for a small business. It has to be an offense for all. But the penalty can be different. And already the Act contains different penalties for individuals and companies. So that's possible. But if I could just re-emphasize my point, I don't think that it should be an offense to do anything that's a question of judgment. Offenses should be things that are black and white, that are objective. You know, you didn't pay on time. You failed to keep this record. It's a black and white thing. Where you can argue about whether it's this or that, that should not be an offense. That should just be for compensation.
Thank you, Mr. Apted. Honourable members.
I'm happy to raise a few other matters if you want, a few other concerns if you want.
Yes,
that, yeah.
perhaps maybe you can raise other
Yes.
matters that you think.
So there's also the Form 9, the schedule. Okay? Okay.
Going to ask that.
Yeah. Form 9 seems to me to have been brought in for the reason I said earlier. The ministry, for its own reasons, skills reasons, has not been able to use the same kind of forms that the police, the DPP's office, the LTA, that everybody else in the government uses. And because they don't have the skills to do it, they want to change the rules to something simple. The problem with their form is they combine civil and criminal. Those are two separate jurisdictions that require have different rules about what must be told to the person charged or being sued. That's number one. Number two, the reason that the criminal forms and the civil forms that you need have all the detail that they don't want to give is to protect the accused, to give them the information they need. Right? So by simplifying, they potentially breach the rights of that person because they don't get enough information about what they're charged with and how to defend themselves. Right? the third thing is simplified forms usually are only justified where it's the public that has to use them, because the public can't be expected to have the technical knowledge of how to do things. But this form is for the ministry, not the public. It's going to be used against the public. So I can't see any justification for it. If they have a problem with the proceedings that they bring because their pleadings are not correct or anything like that, it's for them to up their skills and hire the correct qualified people who can prosecute in the same way as any other government department or statutory body prosecutes. Like, why do they need this simple hybrid? It's convenient, but it will prejudice the public because you won't get enough information to enable you to defend yourself. They don't regulate what you need to include in the form. So that's Form 9. The other one that I think is a big worry, there's two things. This is about liability for unfair and unjustified dismissal. Okay? At the moment, you have to report a grievance within 12 months. There is no limit on time for dismissal. But there is a limit of $40,000 because you have to go to the Employment Relations Tribunal. Okay? There is a feeling in our community that that's unfair. But in fact, it's not. In England, where unfair dismissal was invented, if I could just explain unfair dismissal. Before unfair dismissal, there was wrongful dismissal. And wrongful dismissal is where you sue, and all you can get is the amount you would have earned during the period of notice. So if you sue for wrongful dismissal and your contract says 1 month's notice, you can only get 1 month's pay as damages. In England in the 1970s, they invented unfair dismissal to improve that. Okay? So you're not limited to the period of notice. But they recognized in England, in Parliament, that doing this would make businesses, could bust businesses, could destroy businesses, make them bankrupt. Right? So what they did was impose qualification time. You can't bring an unfair dismissal claim unless you've worked for 6 months or 12 months. And they also imposed a cap. You can't, even if you win the unfair dismissal, you can only get this much maximum. Okay, so that's still the case in England. In Australia, it's still the case. In Australia, you have to bring an unfair dismissal claim within 21 days. You got to bring it straight away. You can't bring it unless you've worked for either 6 months for a large business or 12 months for a big business. And that's because that's to allow businesses to try you out. Now, at the moment, in Fiji, you hire somebody, they don't work out. If you dismiss them, they can take you to the tribunal straight away. So you're frightened to employ. In Australia, it's after 6 months or 12 months you can bring it. And in Australia, the maximum you can get, if you're successful, even before that, there's people over a certain level cannot bring it at all. So it's 140,000 or something. If you earn more than 140,000, you can't bring an unfair dismissal claim. And that recognizes a major reality in business. And I think the member Semi will understand it. When you run a business, the higher level people, like your CEOs and your general managers, if they're not working, you need to get rid of them. You know, like you have to be able to change your top to save the bottom. And if you can't find you can't prove they're doing anything wrong, you haven't been performance managing them, you must still have to get rid of them, right? Where there's a cap, where there's that level, this allows businesses the opportunity to get rid of the top. And they have enough bargaining power to make sure that their salary that they earn while they're there covers that risk. So there should be a cap, right? The second thing is there should be a time limit so that businesses can take the risk, create employment, right? Whether it's 3 months, 6 months, 12 months, I don't mind. But there should be a time limit. You shouldn't be taken to tribunal after you just hired somebody for 2 days and they didn't work out, because then you'll be frightened to create employment. In New Zealand, you have to report it within 3 months, I think, and the Act says the usual award will be 3 months' pay. In Australia, 6 months' pay. In New Zealand, 3 months' pay, unless there's special circumstances. So overseas, in the countries where we want to attract investment from, there's a cap. In Fiji, at the moment, and in the bill, there's no cap on time of service, there's no cap on income threshold, and there's no cap on compensation. So it becomes very risky to hire, and when you need to fire, you don't know what your exposure is. The next thing is, what they've done in the bill is they have extended the limitation period for grievances and disputes to 6 years. Like I said, in Australia, it's 21 days for unfair dismissal, because a business needs to know quickly what its exposure is and plan. Otherwise, you're sitting, you can't distribute profits, you're wondering about liability for an extended time. The more troubling one, and this is really important, is the 6-year limitation on disputes. Okay? You need to understand what a dispute is. A dispute is a difference between the union and the employer. Disputes are mainly, generally, about logs of claims and collective agreements. It's about how much pay people should get, how much pay increase, how much allowance there should be. Those are disputes. Okay. What happens is the union will make a claim against the employer. Okay? You negotiate, you deadlock, you can either agree, great. You deadlock, you can't agree, it sits there until the union reports the dispute. Currently, they have to report it within a certain period, 6 months or 12 months. So at least it's logged, you can go to tribunal, you can provision for it. When you extend the limitation period for 6 years, the union can sit on it. That pay claim for 10% you think has gone because they're not pushing it. But 5 years later, they bring it up, and if it's allowed, it's backdated 5 years. And you will then, all the increases that you've given after that will be on top of, will be compounded. So why it needs, unions need, or employers need 6 years to report a dispute, I don't know. Because if you really wanted that pay rise, log it straight away. Because business can't run when things are not known. You have to know your liability so you know how much you can borrow, how much dividend you can pay. This is a recipe for disaster. And I mean, I know from my own work experience that trade unions often bring overtime breach claims after 6 years because they love these big amounts of money. And the employer then struggles to find the funds. You know, and if they'd brought it early, the employer, and they won, the employer could change its work pattern. But instead they wait. So, they wait to allow you to keep breaching like a savings, then they whack you. So restricting it to 6 months is fair, because if there's a breach, bring it forward, decide it. If you're right, exposure is limited. We can fix it. This is they sleep on it, and so in order to get one big back pay. And that shouldn't be allowed. I mean, yes, workers' rights should be respected, but they need to bring it forward quickly. So there's that. What else is there? Hours of work. There's a problem with the hours of work provision. They're amending the hours of work provision, section 72, the amendment to the management definition, on the assumption that that will mean everybody who earns 32,000 and less will be paid overtime penalty rates. I don't think the section will work like that, but also just because government pays overtime to those who earn 32,000 or less doesn't mean that that should be the threshold for private employers. I mean, you think of all the little businesses. Let's think of all those little tourist resorts in the Yasawas, where the staff from the village or wherever work. You're a manager of that resort, you will work longer hours. You know, like, you can agree with your employer that this will be your fixed sum, and you run the business. You know, by imposing a mandatory overtime provision, you impede those sorts of businesses. The other problem with it is it doesn't recognize the flexibility of the current kind of economy. So the assumption is that if you work more than 8 hours a day, 5 days a week, you should be paid overtime. I have staff, especially female staff, who would prefer on certain days to work 10 hours today and 10 hours tomorrow, so I can take 4 hours off to go look after my child after school or something like that. These kind of rules don't allow for that kind of flexibility. They don't allow for the flexibility of IT kind of work, right, which is unsupervised, or accounting work, where you might have to work late, but that's because you were stuffing around in the morning. Overtime rates work best for like situations where people don't control their own hours, like a factory, or where the boss tells you, now finish, not for unsupervised work. So that's the problem with that provision. Redundancy, the redundancy provisions, the 60 days and the 3 months and 2 weeks will make it very, very difficult. You know, so we don't know how long this war is going to be going. We had to do a whole lot of redundancies during COVID. People have been assuming that that's gone. We have another crisis now. We don't know how long this war is going to be going. If the airfares become too expensive, it's prolonged. Airfares become too expensive, the hotels will have to start slacking. Maybe government will have to start slacking. Ordinary employers will have to start slacking. You know, and so suddenly, in order to survive, you need to let these people go, but you don't even have, and you're letting them go because you don't have money, and then you're faced with this huge expense to let them go. So it just seems weird to me. The last thing, if I may, the last thing is to do with the union contracts, okay? There is, with all due respect, a fight that I constantly have with the union about what is the true position on employment contracts. The correct legal position at the moment under the ERA is that everybody has an individual agreement. That's your employment agreement. That's what makes you a worker. If you join a union and the union has a collective agreement, the terms of the collective agreement get implied into your individual agreement. So you get the better of the two. So if your individual agreement has 15 clauses and one of them says your pay rate is $2, the collective agreement says $5, you get $5. But the other 14 still apply. In this legislation, the union has managed to persuade the ministry that there should be a rule that every time you hire a new employee, you have a collective agreement, just assume you do, you have to offer the new employee an individual agreement, a standard agreement, I don't even know what a standard agreement is, and the collective agreement, and allow them 1 month to choose. If they choose the collective agreement, if you want to add any terms to it, you have to negotiate it with the union. Okay? That is bizarre, because the collective agreement doesn't have your position in it. It doesn't have your pay in it. And it doesn't have all of the terms that the employer wants. You know, sort of like confidentiality, follow the policies. There are many terms and individual agreements that are not in the collective. So this will be completely unworkable. It's copied from New Zealand, but with important mistakes. In New Zealand, everybody has a contract of service, which is an individual agreement. The Act says that the terms of your agreement come from a collective or an individual, but employers and individual workers covered by a collective can negotiate additional terms. So here, we don't need that system because the current system works fine. But if we're going to copy New Zealand, we should copy it all. Like, don't give the power to the union to negotiate individual terms. The union is the collective bargaining agent. It's not the individual bargaining agent. And if that's the case, if the union is the one who bargains the individual terms, it will hold everything up because they're busy negotiating with plenty employers. So it's a completely unworkable system. The other thing that's a huge issue is the bargaining fees. In New Zealand, they have bargaining fees, but New Zealand is highly unionized. But in New Zealand, bargaining fees don't apply unless the union reps have all voted for it. It's not a matter of law. Here, they're requiring bargaining fees to be paid every time some benefit that's in the collective is extended to the individual. The false assumption in that is that everything in the collective has been fought for by the union. Sometimes it has been, yes, but not always. Sometimes what's in the collective is what the employer was going to give anyway.
Anyway.
So why should the other workers have to pay the union 1 year's subscription for getting those terms? So will the union members pay all the other people when they get a similar terms to the individuals? So it doesn't make any sense. The last thing that I wish to raise is about strikes. At the moment, a trade union and an employer are strikes and disputes. At the moment, a trade union and an employer can negotiate. If they reach deadlock, either one of them can report a dispute. Under the old Trade Disputes Act, the dispute could be referred to the tribunal, arbitration tribunal, and if it was over a log of claims or a claim for a contract term, the tribunal had the power to make the agreement, to say the pay rise should be 5% or your overtime should be 1.5 times. It could make the agreement. The current ERA gives that power to the arbitration court, but it doesn't give it to the ERT. That's an oversight. So what that means is, although the ERA allows you to report a dispute over a log of claims, the ERT currently has no power to determine it, to decide on who's right. It can only send you back to negotiate. Okay, so there's that problem. Then the other problem is the ERA as it stands allows the union to take strike action over anything. So long as they take a strike ballot and the strike ballot is 6 months old, you can take strike action over anything. This leaves the employer at a disadvantage, right? Because if you're faced with a strike, you're going to give in, especially where there's no mechanism for somebody to determine who's right or wrong, right? In New Zealand, the Act says you can only strike over a log of claims. You can't strike over Mr. X being dismissed. You can't strike because you don't like the CEO. In Fiji, we've had strikes in recent years because the union doesn't like the head of the organization. So that kind of strike places the employer in a terrible position. You've got no grounds on which to get rid of the CEO. And if you get rid of him, you'll be facing a big compensation claim and maybe even, if this is passed, criminal offense of unjustified dismissal. But if you don't, your workers are not there. So one of the things that there should be is following New Zealand, a restriction on what they can strike for, and also a mechanism to resolve disputes. And not just to say that the court can do it, but the tribunal needs the power to make the award that forms part of the collective. This draft also takes disputes to the employment court. With all due respect, dispute resolution should not be the disputes issue is not suitable for the High Court or the Employment Court. The High Court and Employment Court should be restricted to determining breaches of rights, not what the contract should be. Because when you've got a log of claims dispute, you're determining what the terms should be. That's not a proper function of the High Court. So that's enough of my ramble.
Thank you, Mr. Apted. Honourable members, are there any other comments that you would like to raise?
Honourable Chair, through you, thank you, Mr. Apted, for your contribution this afternoon. One of the concerns is that now that the ministry might be taking over the DPP's role, and that's a big worry. What safeguard that is in the bill you see that can prevent over-enforcement or selective prosecution motivated by this revenue generation?
They need to come out, there needs to be provision allowing the DPP to, to nolly the prosecution or charges to be consented to by the DPP. So that, there's somebody external, who's specialized, but who also brings a broad national perspective. Because this is the other problem with the penalties in here. The penalties are fixed as if employment is in a different country. So the penalties are far more serious, higher than for more serious offenses in other legislation. Like for sacking somebody, you've got this huge fine, Whereas for actually doing something more serious under the Crimes Act, you've got a small fine. Like there's no proportionality. And the DPP will be able to bring, because they have that broad experience and that broad purview, they'll be able to do that. It's about accountability and checks and balances. They need to be in the game.
Thank you, Mr. Apted. Any other last comments, honourable members? Honourable Correll Basal?
Thank you, Mr. Chair. Thank for your presentation this afternoon. Basically, it sort of gels with the general discussions that we've had to generate over the last 6 months. We've been looking at the bill. It's not an easy bill, and I think one of the issues that have been raised by businesses, which you have also highlighted, is fines and penalties. And one of the issues that they had highlighted was that it looks like it is a revenue generation for the Ministry of Employment. One of the issues is that they have tried to establish is the Employment Relations Fund. You have highlighted that there's a consolidated funds that is put in a budget annually, and then every ministry has an opportunity to get the funds from, instead of having separate funds for each ministry to have their own initiative and derive the funds from that as trust funds. The discussions have been in between the trust funds operated by the Ministry of Employment, and that the other option is to have all this revenue put into consolidated funds, and then the Ministry of Employment then ask within their budget application to be provided this budget for any expenditure within the ministry. What is your personal thought on that?
Thank you very much. Through you, Mr. Chair. The correct position, I think, is in between that. Okay, they can have a trust fund. The Constitution allows you to have the consolidated fund and any other fund as long as it's established by law, and that's fine. But you can't spend from your fund unless the budget has approved expenditure from that fund. So it doesn't matter whether it goes into consolidated fund or you create employment relations fund so that you can see how much you made, but your expenditure, even out of that fund, is not at the minister's discretion. It has to be appropriated by Parliament. Parliament has got to say, for salaries, X, for this, Y. That's what the Constitution requires. All expenditure has got to be approved by the representatives in Parliament. You can't have a minister deciding how to spend public funds with no accountability.
Yes, Honourable Sakur.
Honourable Chair, through you, you mentioned about flexible hours. What is your view on this current bill that we're working on? You believe that we should have provision for flexible hours in it?
There should be, but and for alternative forms of work, because that's how we need to start moving. And we need, like people who want to come and work here, live in Fiji, work, but doing work for Australia, different hours, outsourcing, women especially, young people. They don't want to work 8 to 5 every day. There's young people who want to work 10 hours a day for 5 days and take the whole of next week off. And the way that the kind of work that we do now, where people can work alone, allows that. We don't all work in a factory where we all need to be there. So there should be, there's rules already for factories, but we shouldn't extend those rules to everybody. We have to allow flexibility. The hours of work provision, section 72, will prevent flexible hours. In New Zealand, where that's copied from, it says you have to prescribe the hours, but how much you get and what your entitlement to overtime has got to be agreed between the parties. Here they've put the 8 hours into the regulation, but it's based on factories that the unions represent and the government workday. They don't have a view of how everybody else that's not unionized, modern businesses operate. I mean, in a maritime business, people don't work 8 hours. You know, yes, you try to give them 8 hours, but something's happening, you work 10, 12, and then you have days off when you're in port. You need that kind of flexibility. And your crew are not getting 32,000 and more, they're getting 10, 12, 14. But you need flexibility. All the businesses are different. These rules are very civil servant and factory.
Thank you. Honorable Teodoro.
Thank you, through you, Chair. If passed in its current form, what are the long-term implications of this bill for employment relations?
For employment relations as opposed to the economy. For employment relations, thank you for the question. For employment relations, it will... Okay. I'm not anti-union and I'm not anti-worker. I'm actually very pro-worker and I fight for unions as well. But there needs to be a level playing field. This bill, if passed, I don't think will improve workers' rights necessarily. All of these offenses won't improve workers' rights. All they'll do, because if you're a bad employer, you'll still be a bad employer. Whether the fine is $2 million or one, you're still going to be bad, right? Just like we've got drug dealers, no matter what the penalty is. What it will do is make people frightened to employ you. So there's that. As far as what it does is greatly strengthen trade unions and trade union leaders at the expense of employers, which is not the same thing as workers. Trade unions will tell you that they represent workers, so therefore what's good for the trade union is good for the worker. Not necessarily. What this does is give all powers to the trade union leader, taking it away from the individual worker. Because now in the bill, individual terms have got to be negotiated by the trade union, not by the worker. The function of the trade union is not to represent all workers for all terms. It's to bargain the collective bargaining for the minimum terms, and then you can agree individual terms on top of it. This will, sort of greatly strengthen trade union leaders at the expense of employers and the members. It also non-unionized workers, because now the non-unionized will have to pay the penalty of the bargaining fee. So it will, tilt. To answer your question, member, it will tilt the field in employee relations and strengthen the role of the ministry. Yeah.
Okay. Any other questions? Honorable
Chair, sorry, I just wanted to have a follow-up questions on flexible hours in relations to productivity. There has been a lengthy discussions that within the bill, even though it has provided every ambit to increase work benefits for workers, it has not addressed productivity. And most of the big companies and the employers have stated that they have a problem with workers not coming on Monday and on Friday. So that is a question of productivity within their working area. That led us to discuss flexibility or flexible working hours in the week. Okay, say for granted for 48 hours, you can work within 4 days,
Yeah.
or you can work 3 days, 2 days off, and that means you do not have to come when there's a big party on Friday, don't come to work on Monday. And the employers think that this is good for their own working productivity, because the flexible hours will give them the opportunity to create working activity within the 3 days in the week. What is your opinion in that fact?
Yes, I mean, I agree. The bill, the current act and the bill, by focusing, this is my point about 72 and the regulations, by focusing on fixed hours and this compulsory overtime after 8 hours or 9 hours, totally discourages flexible working hours. And by bringing in this $32,000 and below cap, it does that totally. If workplaces and workers are happy to work shorter weeks, shorter number of days, then we should allow them to do that. We should be flexible. You know, we tried it during COVID, it worked, but what we're doing is we're going back to this factory idea, this civil service idea of everybody working together the same number of hours, which is not necessarily suitable for all workplaces. The ERA should be enabling. It should be a framework that allows different businesses and workers to earn and be productive in the best way that suits them.
Thank you very much. Are there any other questions that you would like to raise? Honorable Sakuru, you have another question? No? Okay. If there are no other questions, I would like to take this time to thank Mr. Apted. We would like to sincerely thank him for availing himself and coming up with some very constructive comments, which will assist the committee in improving the contents of the bill. And I would like to thank you very much for availing yourself, and thank you for your time. And if you have any other further question, we shall be coming to you and maybe send you an email. So, honorable members, we thank you very much for the meeting. It's now adjourned. Vinaka.
Thank you, Mr. Chair. Thank you, members.